Good afternoon. Welcome to the House Judiciary Committee. It is February the 1st, 2024. We have 4 bills that we're going to be hearing today, beginning with Delegate Kaufman's first bill in front of the committee, House Bill 115. Delegate Kaufman, if you'd like to begin, please.
Thank you. And I have 3 minutes, correct? Okay, very good. First, I just want to begin and take up 1 second of my time to say how delighted I am that our dear friend, Delegate Simmons, is back around the table. But good afternoon, Chair Kleppinger, Vice Chair Bartlett, and esteemed colleagues. For the record, my name is Delegate Aaron Kaufman, District 18, representing Montgomery County. In a few moments, I will introduce to you my constituent, Ms. Giselle Merck, whose story helps illustrate the necessity of House Bill 115, the J.C. Webster Victims' Rights Act. Ms. Merck is one of many with similar stories. I'll let Ms. Merck tell her own story, but after the heinous murder of her son, quiet please, Ms. Merck received a notification when one of her son's killers was paroled. However, the only other information on the notification was a generic 1-800 number for the Department of Public Safety and Corrections, or instructing her to call 911. And you can read how unempathetic and formulaic and boilerplate that letter was. These letters, as you can see, are impersonal and lack the support the victims deserve. As such, I'm introducing HB 115 to reduce the negative mental health implications and trauma victims experience when they receive the notification of release, because it is re-traumatizing. And one of the reasons I ran for office was to work on mental health. The legislation requires victims, their families, and witnesses to be notified that their killer is being released from confinement. Notifications must also include the name, phone number, and email address of the victim services coordinator of the state's attorney in the county where the defendant was prosecuted. HB 115 prioritizes the mental health of victims and their families. Though it may seem like a minute change, including the contact information of the victim services coordinator will connect victims to a person with whom they can share their fears and anxieties. The legislation will also have a widespread positive impact and ensure that victims have access to the support and resources they desperately need. This was Senate Bill 684 in the 2023 session and passed the Senate unanimously. I am honored that in the current legislative session, 5 members of the minority party have signed on as co-sponsors of this legislation, including Minority Leader Jason Buckle. Importantly, I believe the Maryland State Attorneys Association is also in favor of this legislation. I urge a favorable report on House Bill 115. I'll gladly take questions, but seeing that I have an extra second, I want to thank my colleague, my wonderful intern, Sarah Field, for drafting this testimony, and I urge a favorable report on this common sense bipartisan legislation. HB 115. What? Oh, Ms. Merck.
Excuse me 1 minute, please. Sorry. Good afternoon, Chairman Kleppinger and distinguished members of the committee. My name again is Giselle Merck, and I'm from Silver Spring, Maryland, in Montgomery County. I hope you will please support in favor of HB 115, the Criminal Procedure Victims' Rights Notification of Release from Confinement, the J.C. Webster Victim Rights Act. On July 2017, my only son, J.C. Webster, was murdered. I went on local television and I said, I saw what you did and now you're going to have to come after me and may God get you. During the sentencing of the particular inmate, I was told in court that, well, if you want change, you're going to have to change the law. That's one of the reasons why I'm here. I'm a traumatized victim and ask for your support of HB 115. I've attended numerous parole board hearings, and now on June 8th, as you can see on this letter, June 8th, 2022, I received a note, not a letter, a note from the Department of Public Safety and Correction Services informing me that this person who was an accessory to the murder of my son, JC, and to whom I threatened would be at that time released on August 1st, 2022, and that Public Safety and Correction Services will no longer be involved. The second page of the note, as you will see, has information regarding if I feared for my safety to contact my local police, who they're still trying to get more in the police force, as well as then given a 1-800 number to call. My son JC would say, I may not change the world, but I want to inspire many. I ask you to please be a change agent for not just my son, but for all victims who are victimized and treated poorly. Please be the inspiration that we need to help protect and uplift traumatized victims. I believe this bill will help other victims not feel the stress for their lives, not having to look over your shoulder. Please let this inspire you all to have a system work for the victim who is experiencing trauma. Please don't let my family be a victim all over again. Would it have to take me being dead next? So I thank you all as a victim, because victims are tired of being victimized. We've already had to go through writing victim impact statements and whatnot. It's a lot for a victim. Thank you for your time.
Are there questions for the panel? Seeing none, thank you both very much, and we will let JPR know that you're on your way across the street. Thank you very much.
Thank you.
That concludes the bill hearing on House Bill 115. We're going now to House Bill 311. Delegate Simpson, please. Delegate Simpson, Stacey Bensky, Wendy Blackwell, and April Hamilton. Then there are a number of other witnesses who we'll hear from. Okay. Since this is a new bill, we'll do 3 minutes for the sponsor, 2 minutes for everyone else. And Delegate Simpson, when you're ready, please go ahead.
Good afternoon, Clerk Clippinger, oh goodness sakes, and my fellow members of the Judiciary Committee. I am here to ask for a favorable vote, a yay vote on House Bill 311, child support suspension of driver's license suspensions. So in short, we all, I believe, agree that a child's well-being relies on a parent or guardian's ability to be able to earn income to support that child. If, when their license is suspended, most of us, we know, most Marylanders need to drive in order to work, to get to their jobs. If their license is suspended, then they may be unable to work. And what we are seeing, an overwhelming number of individuals that end up, because their license is suspended, losing their jobs. When they lose their jobs, it is very difficult then to find another job. And how do you support your child? We also know we are at a very large fiscal restraint. We're having issues with our, so if you do not have a job, what is going to happen to your taxes? You don't have enough, you don't have as much income, therefore you are not as paying as much in taxes. We are seeing, as far as numbers, when it comes to license suspensions, anywhere between 17,000, 20,000 a year. As a former child protective services worker in the child welfare field, I also know as a formal single parent that we have lots of ways that we can collect funds. We can garnish wages, we can intercept, and those ways tends to work. When someone applies for a license, for child support, there is a waiting, of course, period to go to court. And as a result, they are already in arrearage. So most individuals are ending up, they're paying their child support, their monthly, and they're paying an arrearage amount. It is not too long before you're going to get to that 60 days and run the risk. What we are seeing throughout the state is that notification is not necessarily consistent. And I want you to consider the child's welfare as well as the welfare of the amount of time that is taken in restoring license that should not have been, that were erroneously suspended. And we are seeing numbers in around 7,000. So you're talking about 17,000 are being suspended, 7,000 they're having to restore, 7,935. That is an unbelievable. Do the math yourself and think about how much the state is putting into restoring these licenses, the loss of income, the loss of revenue that we're receiving. Thank you.
Sorry. Okay, I didn't see the clock go. Good afternoon, Chair and members of the committee. My name is Stacy Bensky, and I'm an attorney at Maryland Legal Aid. The MVA reported over 20,000 license suspensions for child support in 2023. That is staggering. When you know the stories and faces behind that number, it hits even harder. I assist parents with license reinstatements, but often the damage has already been done at that point. They already have a criminal citation for driving on a suspended license. They already lost their job or had their car impounded or missed an important event in their child's life. Fixing it on the back end is too late. Not to mention it's not a permanent fix because the automated system used by the child support agency will simply suspend them again a few months later, even if they now have custody of their child, and even if suspension means they will lose their job. After parents have their licenses reinstated, they are resuspended again and again because of the agency's unfettered, punitive, and predatory automated system. This bill will help break the cycle of poverty. It will allow people to secure and maintain steady employment. Steady employment can be garnished each month for child support. Steady employment means taxes for the state of Maryland and tax refund checks that can be garnished for child support arrears. The answer is not placing barriers in the way of employment, but making employment accessible. So I've stood before or sat before this committee for several years advocating for reform of the child support agency's driver's license suspension system, because there's a river of Maryland residents drowning in a flood, and I can help them one by one with license reinstatements, but you have the power to put up a dam and stop the drowning. So please stop this automated system. We urge a favorable report for this bill that will provide due process and allow the judiciary to make determinations of appropriateness before license suspensions. Thank you. And I urge you to read my testimony, which includes client stories that I don't have time to tell you in 2 minutes. And I'm more than happy to answer any questions about like funding or fiscal that I've done a lot of research on. Thank you.
Good afternoon, Honorable Chair and members of the committee. I'm Wendy Blackwell. I'm the director of the Practitioners Leadership Institute at the Center for Urban Families, where we're a workforce program in Baltimore City. We support House Bill 311 because it supports families by ensuring that harm caused by removing the parent's ability to drive is only used in appropriate cases. It's important to know that only 8.5% of the jobs in Baltimore City can be reached by public transportation. That means 91% can't. And the driver's license is very important to helping folks maintain their employment. The MVA reported that they suspended the 22,000 driver's license for child support arrears last year. It's important to know that the ABLE Foundation found that 42% of the individuals who had their license suspended lost their jobs, and 45% of those who lost their jobs couldn't find another one, and 88% who did found jobs at a lower paying wage. House Bill 311 seeks to resolve this by ensuring that before Child Support Enforcement Administration notifies MVA of the obligors in the arrears, a circuit court hearing needs to be established to determine if the suspension is appropriate. This is a rational approach to ensuring that the state is not needlessly endangering the well-being of families by limiting the obligor's access to employment and quality time with the child. For these reasons, I urge you to vote favorably on this bill. Thank you.
Hi, my name is April Hamilton. I'd just like to thank you for allowing me the opportunity to speak here today. I'm a resident of District 8 and I support the House Bill 311 to ensure that driver's license suspensions for inability to pay child support are used in appropriate cases. I have a 10-year-old daughter from a previous relationship and a 9-month-old that I am raising alone. I left my previous relationship after surviving multiple domestic violence situations with my ex, my 10-year-old's father, and then I moved to a domestic violence shelter. The obstacles were insurmountable. Without any familial support, I struggled for years to gain a license, a job, a car, and housing. Due to my unstable situation, I lost custody of my daughter, and my ex then placed me on child support, where I had my wages garnished and my license suspended. I lost my home and eventually my job. My quality of life plummeted significantly, and I had to reach back out to him, to my abuser, and plead with him to drop the order, which he eventually did. I am very thankful that the situation worked out the way it did, but no one should have to plead with their abuser to repeal a child support case. Years later, I took the opportunity to better my situation by moving to Alaska to work on a cruise ship as a waitress. During this time, he placed me back on child support again for my daughter, but because I was not in state, I did not receive the communication alerting me of this change. I did not receive the court order to push back. I now owe him more than $20,000 in arrears, and my license has been suspended since April of last year. There is no way that I can pay down this debt. I have been frantically searching for employment opportunities, but have been turned down several offers due to not having a license. If this bill were to pass, I can make a case in court, retrieve my license, and improve my situation, my ability to support both of my children, one who loves to make noise in court hearings, and improve my circumstances in my life. Please pass these bills.
Good afternoon, Chair Clippinger, Vice Chair Bartlett. My name is Nashana Kess. I am the Executive Director for the Maryland NAACP. And also good afternoon, members of the committee. Thank you, Delegate Simpson. We stand in favor of House Bill 311. This serves as a means to essentially provide due process to those in danger of suspension as it relates to failure to pay child support. The intent of child support is to provide monetary support to the custodial parents to help assist with the care of the child. When one loses their license, they may lose their ability to work. Losing their ability to work may provide for further arrearage in child support. I want you to consider many of the rural areas here in Maryland. In particular, let's say the Eastern Shore. There is no public transportation. So there's no means for these individuals to provide an alternative to get to work. Uber is expensive. How can one pay for Uber if they don't have a job? This ability for those individuals to be heard and exceptions applied to retain their license to work may continue to help them pay child support and assist those children in need. Currently, and now I'm reading from what I submitted in writing, 71% of the license suspensions between 2015 and 2020 are made up of Black parents, which is an absolutely deep concern of the Maryland NAACP. Child support debt also contributes to arrests and incarceration, which further impacts communities of color. It should be best practice to allow individuals the right to due process when facing suspension of their license. Thank you.
Questions for the panel, Delegate Kaufman?
Thank you. This is a question for Delegate Simpson, but you may defer if you wish to Ms. Bensky. First of all, I support the bill. It's very important, but I do have a concern. When I was preparing for the hearing this morning, I read a letter of information from the Attorney General's office that said that we could lose federal funds as a result if your bill is successful. And I was wondering if you agreed or disagreed with Attorney General Brown's staff, and if he's accurate, if you had thought about ways to fill the gap from the loss of federal funds, given that my colleague Jared Solomon, who's on appropriations, the Appropriations Committee, says this is an eat your vegetables time.
Well, thank you very much for that question. I really appreciate it. When Delegate Taylor and I were preparing this, and we've been preparing this pretty much since last time, we were in session, and we reached out and we spoke with Anthony Brown himself. So we were a little surprised by this letter because we'd also spoke to Hannibal. When we prepared this, we specifically look at the federal statute. And the federal statute requires states to identify when it is appropriate to suspend license. Maryland has never done that. It's simply been based on arrearages. I would also like to point out this is based on our national, conference of state legislators, their research. Over 21 states have a hearing-based suspension and have not lost their federal funding. All this does, as far as this, why we are putting this forth, is because Maryland suspends, as I said before, if we're talking 17,000 or 20,000, and MBA is saying we're restoring 7,900 of those suspensions that were erroneously done, it's almost half that they're putting back, and that people are either losing their jobs or being pulled over, driving without, on a suspended license, having to pay that $500 and some. So the goal of this bill is actually so that they're only being suspended when they should, when we have clear and convincing evidence that an individual has funds and is holding those funds, rather than the individuals that are already paying monthly child support plus their arrearages, and just so happen because it goes beyond the 60 days or get caught up in that computer system, are now getting their license suspended. We want to make sure, we know that, we want to reduce the number and only have it occur when it should occur. And that's why we created this bill together, to identify when it is appropriate. So we were a little surprised by that. I think it's a new individual in that role, and it actually looks very much like some other child support testimony that had been done in former years. We specifically crafted this bill to make sure that it addresses when it is appropriate and it still matches our federal requirement. And I also want to point out the federal requirement is specifically about the welfare of the child. Child support is for the welfare of the child.
And if I could also speak to, I'm in a family law work group with family law practitioners all across the entire country. And one of the issues we talk about is the child support agencies and driver's license suspensions. And we have talked about these federal requirements at length. There are so many other states who have requirements similar to this, and it is absolutely in line with the federal, with the controlling federal laws. I have them right here in front of me. And what they say is that all states have to have the authority to suspend or restrict licenses, not just driver's licenses, but professional and occupational licenses and recreational and sporting licenses, when it says in appropriate cases and in order to improve the child support enforcement effectiveness, so the effectiveness of the program. And what the federal enforcement program and Maryland say that the point of the program is to improve financial stability for for children and families. So by making this bill, it's actually, I would say it actually brings Maryland more in line with the federal laws. Because as it is now, this automated system is completely arbitrary. I have clients often where custody has switched, especially in low-income families. Custody can switch overnight because a lot of times both parents, their employment or their housing might not be stable. So the child might go from one to the other. Now it takes at least a year minimum, usually longer, to modify a child support order or a custody order in the circuit court. So even though a lot of my clients have custody of their child, they are still having their license suspended because while they're waiting for that order to go through the court or that motion to go through the court, their arrearages are racking up, but the child lives with them. And even after, to be honest, after they get the orders, often the agency doesn't actually stop the arrearages from accruing because they don't close out the case correctly. I see that all the time. So these are people who have custody of their children. So if you're talking about appropriateness, which is what the federal laws say, I would say it's absolutely not appropriate that my clients who have custody of their children are having their licenses suspended. So it puts us truly in line with the federal requirements and in line with what a lot of other states are doing.
Thank you, Mr. Chair. Thank you both.
Thank you, Mr. Chair, and thank you for bringing this bill. I hope you succeed. Years ago, I tried to get rid of the automated suspension bit myself and didn't quite get there, but that leads me to a question because where we did land when we last moved on this topic, Senator Muse and I in 2017 got the numbers moved to create the 60 and 120 timelines for suspension of a regular driver's license and a commercial driver's license. So if I'm reading this correctly, it basically puts everyone on the 120 days before they have a suspension. But I guess my question is, should we then kick commercial even longer? Because the feeling was then that it should be extra hard, even harder to mess with someone's commercial license because that's messing with the actual means by which they're going to make the support order. And there's other ways, you know, garnishing and what have you that you can get at the funds. So I guess that would be my main question. You know, if we do this, you're seemingly putting all the other drivers in a better position, but leaving the commercial drivers now at the same level.
I have no problem with extending it. And I understand where the logic is coming from, but truth be told, we're all using our car in order to do our job. So I think if we're going to extend it, we still should extend it for all.
Also, if I could say, I think the point behind the bill is that most of the time it's not appropriate. So if you look at the factors for what the bill lays out for when it is appropriate and when it's not appropriate, what this bill says is that it's appropriate to suspend licenses in cases where the parent is voluntarily impoverishing themselves and the agency can show that they are withholding funds. The agency has like they have unfettered power and authority to access funds. There's a whole list here again in the federal requirements of what they're supposed to do of accessing. I mean, they have automated systems that talk to the banks, that talk to other states' systems. So they should be using other ways to get these funds before they're just skipping to suspending somebody's license. So I think it does help also the commercial drivers. I think really the idea is it should be used very rare in those rare extreme circumstances where, like we said, where someone really is voluntarily impoverishing themselves or hiding funds.
Can I interject 1 minute? I just want to also point out, in fairness, I don't think the agency is doing the best they can. It became an automated system because there's such a high number. And in Maryland, we've simply said, when you get to 60 days, we're suspending your license, even if they're actually paying a monthly amount in child support, even if they already have an agreement where, let's say I'm paying my 150, for my child support, and I'm paying an additional 50. So now I'm paying 200 to buy down my arrearages. The problem is, especially with COVID, that time extended, is we, file for child support. I might not get a hearing for 3 months. I might not get it for 6 months, depending on how complicated it is. And then the amount I owe in arrearages is already from day one. And then they have to figure out, how am I paying that down? And for some individuals, it's possible for them to pay it down much quicker if I have more resources. But if I have less resources, it's going to take a lot longer. So and to be clear, I believe everybody in this system is trying to do the best that they can. They developed this automated system because they just really didn't have the staff to do this. And what we are saying is that if somebody is paying their child support, right? If they're paying their arrearages, this is not the tool. We simply took this tool and put it in a different toolbox. And please note, we reached out to the judiciary and they were totally cool with it. So, we're just taking a tool that should be used in a very rare circumstance, very clearly identified by the federal statute, in a very rare circumstance.
Thank you, Mr. Chair. As a co-sponsor on this bill, I have a couple of quick stories to tell you. Please indulge. I have two family members. One that is an Uber driver, or was. He black car service. He did get locked up for a minor offense, and when he came out, automatically he was behind on his his support, but he was able to drive Uber, got a black car service, doing quite well. Was pulled over for something, and they found that his driver's license was suspended. Immediately, his life was declined. He lost his ability to drive the Uber. He lost his car. He lost his, his apartment, et cetera, et cetera. Have another instance where a family member, kind of the same situation, but found it was an error. Right, he's dealing with it right now. He should not have had his license revoked or suspended. So I really want to get to the question of whether this bill is, if passed, whether it would unduly burden certain agencies or the judiciary. So I want someone to explain to me two conditions. What would it look like? What would this step-by-step process look like if my driver's license is suspended and I deserve it? Okay. And two, what if my driver's license is suspended and it's found to be an error? Like, walk me through how we would, get to the bottom of that, and what agencies would be involved.
I think it's pretty obvious that the system is already overburdened with. So if your license should be suspended, we know from what the Attorney General came in and said, a couple years ago, state was sued for not having a due process. I don't know why this was not added in there, because of the lack of due process. When we went, as we know, to the court system, the number of people who said their driver's license was suspended, judge said you're not supposed to drive on a suspended license. I didn't know. I will say that there are some of the, we've got 24 jurisdictions. Some are pretty good. Others, the response that we received when we looked into this was they are warned in every letter that this could happen. I think we can all agree that being warned that something can happen and being notified that it did happen before I actually am pulled over is completely different, right? So if it is supposed to occur, then if you were to go to court and the agency would know you're not paying your support, you're not paying your arrearages, you're behind, therefore they're going to use this tool. They would then petition the court and prove to the court that you are not paying, have not been paying. And therefore, when you get to court, you would know that your license is now suspended unless you produce the money to pay your arrearages. That's not occurring right now. If it is not supposed to happen, currently, as you know, when I met with Frederick, I did not expect this response when I met with child support in Frederick. The director of child support in Frederick said that in 1 year, they had over 700 cases where she had to fix it that they should not have been. And that means contacting MVA. In some of those cases, it wasn't just that they were lost a job or lost their license. They actually lost their insurance, because even though she had corrected multiple times, this computer system continued to show that they were getting their license suspended. And I don't know the whole back end of the insurance, but they're looking at it and contacted this gentleman, was on the side of the road with his cattle, had just been called by his insurance, told that his insurance was being canceled. And he's, of course, calling child support. You know, what am I supposed to do? Because it shouldn't have been. His license was not suspended, but he was losing his insurance, which means then he's also losing his livelihood. And that's what we are trying to prevent, that somebody goes to court, they know this is what they're using, and therefore, before they leave the court, they know their license is suspended, and we're not having the, I didn't know.
And if I can speak to the procedurally to the courts, because I'm in court quite a bit on those family law dockets. So the procedure would be similar to a contempt procedure, because the person would have to actually be served first, whereas instead of just receiving a notice that says your license might be suspended, and when I say receive, I use that with a grain of salt, because my clients, I can tell you, move all of the time. Their addresses are not stable. The amount of times I've lost touch with clients, but then they come back 6 months later, because there's a lot going on in their lives that if I didn't do the work that I did at Maryland Legal Aid, I wouldn't realize how unstable someone's life is when they're low income or living in poverty. So those notices, typically my clients, and I know the PD's office, the public defender's office, says the same thing, that people don't receive the notices. I don't know if it's sent to an old address or whatnot, but it's because there doesn't have to be actual service like there does for contempt. You have to have personal service. And so it would be similar to that. There would have to be an actual service so that the person would know, and that there would have to be an actual hearing and would know that their license is going to be suspended. In terms of who it would affect, I understand that the AG's office has said they would have to hire all these new attorneys. And I'm not sure why, because they have dockets in every single courthouse. They have contempt dockets already. All they could do, they could just add them on. They already have magistrates they're called 4D funding, which is child support funding. They have entire dockets that go just for child support dockets, for modifications, for contempt, and for establishment. So I don't know, I'm not sure why in the fiscal, notes, they're saying they would have to hire something like 17 new attorneys, because they already have those dockets, and the judiciary has said we can fit them onto the dockets. The judiciary said they're favorable on this. So I don't know why. I would say procedurally, I don't think it would have much of a negative effect on some of the agencies that are claiming that it would. And I think it would have a positive effect on the child support agency. If we're talking also, yes, about agencies, because a lot of times I have clients on the other side of it. So not the non-custodial parents, but I do family law. So I also represent custodial parents. So sometimes we have clients that we're representing for custody that say, I think that the other parent is hiding money, but I reached out to child support and said, can you do something? Can you file for contempt? Can you suspend his license? And they said, well, we just have to wait till it comes up in the system. We can't do anything. It's an automated system. So they could actually, instead of dealing with all these reinstatements of incorrect, erroneous, and inappropriate suspensions, they could use that time to maybe investigate that person who they got a call about that they believe they are hiding funds, where it actually might be appropriate to suspend that person's license, but they're getting away with whatever they're doing because the automated system hasn't caught them.
And the goal is to reduce the almost half erroneous suspensions, keep people employed, stay employed. You can continue to support your children, and therefore they're also making an income that is taxable. And as we know, majority, over 90 some, almost 100% of income is, they already have the tools, whether it's garnishment, whether it's intercepting the money out of a bank account, intercepting their taxes, whatever it is, even if they're contractual, they have those tools. Thank you.
To the last comment on the erroneous suspensions, are you saying instead of using the suspensions as a starting point, you would want to use the garnishment and other interceptions as a starting point?
They already are using it as a start. The starting point is supposed to be that. Unfortunately, as we know, sometimes, with how long it takes perhaps to get a court case, sometimes they are beyond the 60 days that's in the law already. So they're already possibly subject to having their license suspended, even though they're just getting started.
So you're saying that when the filing starts, you receive a letter that your license could be suspended or it might be suspended, but not until you go to court is it deemed that your license is suspended.
That's not the way it is now. As I said, 21 states have a hearing-based suspension. We do not. It is strictly the department that is notifying MVA and them suspending. We know it's also a computer system that is really doing this based on the information because it is so overwhelming, because it is so many. This bill is going to do exactly what you say, which is that they are being intentional about suspending license when it is appropriate. This bill actually is defining when it is appropriate to suspend a license.
So if the license is suspended and it's found out to be erroneous, like you're saying, in around 50% of the cases, if the license is restored, does the person receive, or are they eligible to receive a refund of the charges?
No.
No.
But it is in these, what we received is over 7,000 were they able to do it electronically. So if they were doing it electronically, there's nothing on the part of anything that's being, restored other than that's, like I said, that's why they kind of lost their insurance, is because it's still going to show on their driver record that it was suspended. 937 of those had to be done manually, whether or not they, restored anything.
If I can say though, Delegate, also, that's just that were restored through the MVAs and fines. Like, you absolutely are never going to get those back. Those are still going to be on your.
No, you're moving too far down the track. What I'm trying to get to is if the MVA or one of the associates affiliates does an erroneous suspension of your license, and then you get your license restored, wouldn't they be liable for any harm that happened to you?
No.
That's what I'm trying to get to. Who? I mean, if someone does an erroneous suspension of your license, you have no recourse?
There's absolutely no recourse. So right now, there's also no, even though there's supposedly in the law right now, a sort of small version of what they say. They send the notice and that you can request an investigation if you think it's erroneous, and then that the agency, it's in the Maryland regs, that they are supposed to send you the results of their investigation in writing, and they're supposed to include in that your right to appeal it to OAH, the Office of Administrative Hearings. They do not do that. And I can tell you that with absolute certainty. I've been doing this since 2018. So when someone asks for an investigation to reinstate their license, to say, hey, this was done erroneously, for example, like many of my clients who now have custody of their child and have court orders saying your obligation for child support is now terminated because you have custody of the child. So that's an erroneous suspension. The agency still, like the computer still suspends their license when they go to them, and they don't receive any sort of actual investigation. They don't receive anything in writing. Even when I try to appeal cases to OAH, there's a lot of times issues because OAH will say, an Office of Administrative Hearings will say, to set in the hearing, we need the notice because there's specific dates that they're supposed to do it in. And I say, there is no notice. The agency won't give me a notice. They just tell you verbally, no, we're not suspending we're not going to reinstate your license. If you make a payment, maybe we will. And that's it. And these are for people who have custody of their children, people who have lost their jobs, even though it's in the current law, 10-119, that there is supposed to be a process and that they're not supposed to suspend if it would be an impediment to an employment, or for a lot of my clients who are disabled, they're not allowed, technically in the text of the current law, not supposed to suspend if someone has a verified disability, because that's the reason they can't pay child support. So the way the law is written, it is not followed like that in practice.
Yes, okay, well, I understand that, but right now, a key word that's floating around down here is accountability. And if you're saying that the MVA is not being accountable, then
Well, it's not the
It's not
MVA.
the
In
MVA.
fairness, the MVA is just doing,
They're not allowed
What?
to.
it's not the MVA.
Yes, so I can tell you how the process works. It's all child support enforcement. So the MVA has no authority here for whatsoever. And even the laws say that the MVA, once they receive the notice from child support, from that computer system from child support, they must suspend. It's the child support agency that is supposed to be doing all of these investigations. It's the child support agency that they don't have to suspend. It doesn't say in the law shall, it says they may, but they have this automated system. So they've turned it into a shall, but it's not, it's a may.
Because it's so many.
thank you very much.
Yeah.
I don't want to take up for so much time. Thank you very much.
But thank you for your question. We appreciate it.
Delegate Sample Hughes.
Thank you, Mr. Chair, and thank you for the bill. It's very much a healthy discussion. I had just some clarity or questions I needed clarity on. I noticed that the fiscal note, the one-time programming costs about $340,000. Now, this change, a potential change in the system, does that allow the interagencies to talk, meaning that with the gentleman that is in your testimony, Mr. R, where the juvenile court system had granted him his daughter, but he was still, labeled as suspended license, would this new change in the system automatically make that change? Or is it where the client is now just automatically going to get a letter? Is that the communication?
So this should make it so that his license is not suspended at all. But right now, those systems are supposed to talk to each other. And I can tell you that's all in these federal rules that I have them all printed out right here. If you want to study through the pages of them and research it like I have, it's really boring. So I just not suggest it. But, but right now they're supposed to already do that. But I don't know why there's so many glitches in the system, but there are. Part of with the juvenile system is that the juvenile courts, I guess, are different from the circuit court that handles other family law matters. So I've actually had several clients like Mr. R in situations like that, where they got custody of their child through the juvenile court, which is separate from the circuit court. But either way, the point is they have a court order. They bring that court order. They have a court order saying that they now have custody of their child. They bring that court order to the child support agency. The child support agency does nothing. So if you're talking about accountability, that's a problem with there.
I think in fairness, the volume itself is the reason for, the volume of individuals just being that they're, our law currently basically says you're 60 days and you're in arrears and this can happen, and it does happen. Even if, we're going to talk about that carrot and the stick, even though this stick is being used way too often and isn't getting the results that we're looking for, which is why I would say to look at, I am very, very appreciative. Our legislative services work with us. We have been going back and forth. We made sure to contact the Department of Human Services. We made sure to contact the court system. We made sure to contact the AGs and everybody else that's possibly involved. I would think very critically of, even if you read through this, you can see even MLS is kind of like, is that really accurate? Sure, if we were sending them 25,000 cases, I can see the 17 people. We are not intending to do that. I believe this is going to go even much lower than the half. I don't think it's going to be half. I think they're only going to find, for me and my little nerdy numbers, probably about 10% are actually going to fall. And I would say 10% because I think they're going to actually be able to address some of the people who are requesting, who know that somebody has some income. They're saying they make $10,000 or driving, a very expensive car and living in $1 million house. Right now, they're not addressing them because they're spending so much time. Just like I said, the individual, the director from Frederick, 700 cases that shouldn't have been, that you're restoring again and again and again and again. And as I say, 21 states, there's several states that are going towards changing some of this. This law is based in the 90s, right? I don't think the 90s is where we want to stay. It was based on this welfare to work mentality. Right. We want to support children. Federal law says this is supposed to support children. We want to support our income and we want to support our revenues. I think that means that we need to keep people employed.
And just to answer about Mr. R, I just did want to say he also did testify last year in front of this committee, and this year he did submit written testimony, but he wasn't able to be here in person. About that, what would happen is, instead of the license being suspended, because he has to have proper service of a hearing, once he gets in front of a judge would say, okay, it's inappropriate to suspend the license in this case. So that's the difference. It's not a machine talking to another machine that now has all these glitches.
And child support would know this and be unlikely to take them to court.
Right, because they would have to investigate anyway, because this is what that would make them do, to actually look at the situation and say, okay, this isn't appropriate. But if it did get to that court hearing, certainly a judge would realize it's not appropriate in that case.
Okay, so one last understanding, the judge makes the decision on whether or not it falls in line with the federal guidelines of appropriate cases.
Yes.
Is that correct?
And clearly the department would also make a determination before they brought it forth. And that's what we're also hoping. We've given the appropriate guidelines and hopefully they would only bring appropriate cases.
And that's subjective, right?
Well, there's a list of factors. Okay. So they would have to show, the agency would have to show that they have some sort of, it's a clear and convincing proof. So that this person the parent is like withholding funds, but or voluntarily impoverishing themselves. So that's a similar determination. I mean, that's made right now in child support and custody cases all the time. Judges are used to making that determination in child support establishment cases.
And that they weren't already paying child support. They're not already paying arrears. They already have. We don't believe that the department would be bringing those cases forward because once again, they already have an agreement.
Okay, thank you. Thank you, Mr. Chair.
Thank you very much.
Delegates, polls, starting with this is 40 minutes on the first pass.
Thank you, Mr. Chair. I'll be really brief. I just wanted to thank Simpson and Taylor for bringing the bill. I think something does need to be done. As you both know, I have a similar bill that we've heard for the past probably 4 or 5 years. So I just wanted to thank you. I do want to just say publicly, we need to fix some of these types of policies we have, because it does impact minorities more than any other group. So isn't that so?
But thank you.
Don't make me come over there. All right.
I do want to mention that the bills are companion bills. They do not conflict. So the Delegate Toll's bill and this bill do not conflict at all. We made sure to make sure they can be companion bills. If they both pass, they're awesome. If one or not the other, they both do something good for our citizens of Maryland.
All right. Sadly, I have a question. You said the obligor. I've just been waiting, and then all of you keep asking questions, and I've been trying to be not gonna be nice anymore. All right, the obligor is served. I get that. Who serves them?
So the same way that, I mean, for contempt cases, typically, I guess the state would probably uses the sheriffs. That's typically my understanding.
So the sheriff's gonna serve them, or the sheriff's serving
They're-
any of this already?
They're already serving people like routinely. Again, they already have contempt dockets, so they're already serving people for that. I mean, so.
But this is adding on top of what they already are gonna be serving?
Well, I don't know if it would be adding on top of, because it might be the same person. Maybe they're just taking the same people now to court. Is it appropriate for contempt, or is it appropriate for, maybe for license suspension? I don't know that it really would be adding that much more onto the dockets and the service that they're already doing.
Okay,
And remember, there is also the deterrent that once they were receiving this, they would be having the option of paying what their arrears and avoiding this altogether. So, you do have some of them that are going to do that as well.
And Chair, if I may, even if we do need additional supports in the court system, 1, 2, 3 people, that I think
1, 2, or 3 people? How
I'm
many
just
thousands are there?
suggesting if we needed a few additional people, because we did mention
A
17.
few?
or
How many would be a few in this
Almost-
case?
Oh,
This is
the
Most
point.
of those thousands would not be getting to the point of going to a hearing, because most of them are not appropriate for suspension.
They're already paying, they're already garnished, they're already having their income intercepted. That's the problem, is that which we talked about, is that unfortunately there's such a large percentage of individuals that are getting their driver's license suspended who are paying.
Okay, I see that point. Okay. There's no letter from DHS here. There's no position at all from DHS here, which seems remarkable, and perhaps.
And they were informed, and
I've had conversations with them too, and I'm sure they've been informed. I've got that. I guess my question is, well, I'm not gonna do is that so, but they don't have any position on this bill?
they're speechless, and apparently, like we said, Judiciary is receiving it.
I now wish I was. All right, that's enough from this panel. We'll go to the next panel, please. Thank you all very much. We'll go to the next panel.
Thank you.
and-
Share the love.
Thank you, Christopher Dews. I'm sorry. I gotta go to the next
Thank you
panel,
very
and
much.
thank you. I'm sorry. Okay, that's fine. Christopher Dews, Frank Schneiderman. You put a note in my file, Delegate Conaway. That's fine. Frank Schneiderman, Michael Ross. We have a couple people virtually, Duan Burton and Dante Peoples. You only have one. All right, let's stop there, because it looks like we're gonna have a panel after this one, because I'm not sure I'd have quite enough room anyway. So Mr. Schneiderman, go ahead.
Thank you, Chair Clippinger, members of the committee. For the opportunity to address the bill. My name's Franz Schneiderman. I work with a group called
All right,
Consumer
let's
Auto Maryland that works to protect Maryland consumers and Maryland drivers. Support the bill because we really think it's a powerful way to protect thousands of Maryland drivers who are currently losing their license as a result, sometimes of relatively small arrearages here. And, as you've heard, I think that's a really counterproductive practice. It is unduly burdensome for people to lose their license, and obviously when they struggle to make a living without a license, it's much more difficult for them to pay their child support. Now, I've spoken on behalf of similar bills in the past, and I know you folks have heard them. What I really think is attractive about this bill is that it kind of goes to the root of the problem instead of just setting conditions or income levels, as some other bills have done. This requires an affirmative finding by the judiciary that it would be appropriate to suspend someone's license before people's licenses get suspensions, and also requires that people get notification of that process. Because right now, people are losing their license and not even getting notification of it, and then they're subject to big penalties for driving without a license, and they may not even be aware of the problem. So this, and specific conditions, the courts have to find that the debtor actually can pay the money, that the money isn't going to be obligated in other ways, and that it ultimately serves the best interest of the child. So we think that will help get child support paid and prevent a lot of people from undergoing a lot of unfair punishment. Hope you'll support the bill. Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the Judiciary Committee. My name is Cam Bridges, and I'm a senior public policy advocate for the Job Opportunities Task Force, a nonprofit organization dedicated to helping low-wage individuals get access to higher-paying jobs. JOTF supports House Bill 311, which would ensure that before a Child Support Administration notifies the MVA of an obligor in arrears, a circuit court hearing is established to determine if the suspension is appropriate. The standard by which it would be determined if suspension is warranted would include considerations such as if the minor lives primarily with the obligor, if suspension would ruin the ability to assist the custodial parent with the child's transportation needs, and if the obligor is disabled and unable to work, among other considerations. So in a perfect world, license suspensions would only be utilized for obligors who flagrantly try to shirk their parental responsibilities. But we do not live in a perfect world, unfortunately. Legal services such as our friends from Maryland Legal Aid, who help low-income individuals with child support cases, frequently state how often it is for their clients to have their license suspended undeservedly and how difficult it is for them to resolve in a timely manner, thereby hurting both them and their children. This legislation is needed because the reality on the ground is that there are many cases where an obligor losing their driver's license ultimately hurts the child. This bill takes this into consideration and ultimately protects children from being a casualty of the very enforcement mechanism designed to help them. Thank you for the opportunity to speak today, and we ask that you give a favorable report to House Bill 311.
Yes, sir. Christopher Dews, actually representing the Center for Urban Families. Just wanted to say, first of all, it's really good to be in this committee. Haven't been here all year. You guys are wonderful. It's my favorite committee. You're the hardest working ones in the state of Maryland. Just want to put that out there. So you all know that this is an issue that I and the colleagues that have already testified have worked on for many, many years. It's a really important issue. It affects workforce, which was my background. And I want to thank you all for taking the time. Special thank you to Delegate Simpson and Delegate Taylor for really championing this issue this year. And another special thank you for Delegate Tolles, who's been just pleasant to work with on this entire conversation. That being said, me too.
Does anyone have any questions for this panel? The Vice Chair.
Thank you for being here. I have just a question. So, there's a huge fiscal note attached to this bill. Would it be currently when someone is being advised that their license is being suspended, I assume that that's done through the mail system?
Yes.
Right. And so the back and forth is all through the mail system. A person can respond. And could some of this information possibly be put in a letter stating that, our records show that you have $1 million and you're not paying your fees, your child support, and you have X amount of days to prove that $1 million is actually not yours, the very things that are in the bill. Could this be done through correspondence as opposed to having the utilization of the court system?
So that's a very interesting question. I think when we've been having our conversations, and for the record, as the delegate mentioned, we did have meetings with DHS. We did talk to Office of the Attorney General. As Stacey also mentioned, if you're sending these things through letters, sometimes people, especially the people who are the lower income that are disproportionately impacted by this issue, are housing intransigent. So the chances of them getting that letter and then being able to respond properly is going to be just naturally a practical issue. The second part of that is the fact that when we've had clients that have, especially when I was in workforce development full time, we've had clients that have tried to negotiate with and push forward with with child support enforcement. And for the record, I think they're doing a phenomenal job. They're just doing what they're supposed to do. The issue is that sometimes there's not a rapid response. Sometimes you can't get through to them. And many times it just is a system that can be needlessly burdensome and hard to kind of work through. So and I'll say that to say this. For example, in law already, there's always supposed to be kind of provisions that say, well, if this is going to affect your employment, it shouldn't happen. If this is going to affect your access, I think it's a work license. If it's going to impede other court orders, that should already be in 1019. But currently, that's not happening.
Right.
So the reason why we needed this court system specifically, just like it is with contempt court, is primarily because we wanted some type of step before it's taken. If there was a letter system, though that does sound like it would be rather pleasant, the issue that I see is that it would just repeal, continue the status quo. I know that there's conversations with the sponsors right now about how to resolve that fiscal note issue. We have meetings with DHS. It kind of just blindsided us with that $2 million note.
Okay.
But yeah.
All right. Okay. So yeah, I think there should be some resolutions because like for instance, with federal government, SSI, disability or something like that, that's all done by paper. I mean, I'm not saying that the federal government is, well, I won't say what I was going to say there, but it's all done by paper. I mean, a lot of it's done by phone. I hate that it's done by paper, but it is a way so that the individual doesn't have to come in to court. And so, these are just some thoughts. I like what's in the bill. I like the concept of the bill of, CSA having to prove that this person has the funds and they're just not, putting the burden on CSA. I mean, I like that part. I just think that might be a way to streamline it. And no, I've asked my question. And thank you very much for your answer.
Delegate Phillips, Ben Conaway.
So one of the things that I noticed is the court liked this, right? They seem to be supportive. And it seems to me that the courts are suggesting that they're doing a lot of this work anyway.
Yes.
Because of the reinstatements. How much would that, and I know in the fiscal notes, we don't talk about the other side, right? The potential positive impact on revenue collection, et cetera. But could you talk to how this might assist the courts?
Yeah, I mean, time and resources, right? As you all know, we're currently in a fiscal deficit. There's a massive amount of staffing shortages that are happening all over the place. So to be able to repeal this consistent desire, and I mean, and I know the delegate has already had these conversations with them as well, it would be a tremendous savings. Now, the question is, how do we quantify that? Because like, as you mentioned in fiscal notes, we don't tend to quantify how much money is going to be saved if we, move in this direction. We see this a lot with incarceration. It takes this much to incarcerate somebody, this much to train them. But I tend to not see in fiscal notes when we're looking at other issues, the state could save this amount of money. So that's a conversation that we would love to explore with the courts to see if they can give us a quantifiable number. But I do think it would save them a tremendous amount of time and resources. And we know the courts are always backed up. And I want to say there was also a gentleman last year who testified on this issue on the Senate side for different language, but he mentioned, man, if this were to come into effect, then my caseload would be significantly reduced and people would have better access to employment. So it would generally help in that capacity, but I would like to fight for a number.
Yeah, but on the other side of that, because once again, we're talking about fiscal notes, has anybody done any kind of an economic impact study on those 8,000 or 9,000 individuals who were negatively impacted, and what that cost is to the state of Maryland?
Again, hard to quantify because we don't look at these things, but I believe Ms. Blackwell from the Center for Urban Families mentioned in her testimony, I want to say it was of the 45 individuals who had their licenses suspended, lost their jobs straight up. Of that, only about, I think it was in the mid-80s, were able to secure, no, another 40% were not able to secure another position. But when they were able to secure another position, 88% of the positions that they were able to secure were actually of a lower income. So we're talking about less taxpayer dollars, generally speaking, because the income has gotten lower. We're talking about just generally less jobs as a whole, because people are now kind of being forced to stay home. And I know that's been a talking point for a very long time, forcing people not to work. And so the state inadvertently is trying to do that in the name of, and so again, this issue specifically for me, as having worked with trainees who have been trying to secure employment for years, and the only way they could do it was coming through this training program because no other avenue was open to them. This would be a tremendous benefit to families just as a whole. And we haven't even talked about this, but the frustration that comes when you're trying, as the good Vice Chair said, when you're trying to now reach out to the Child Support Enforcement Agency, and there's a level of friction there that then trickles down to, well, why am I in this position in the first place? Specifically for those individuals who have primary custody of their children. And there's an individual, he didn't get a chance to come today. I'm very upset about it. But 15 years he's been dealing with this issue and he's had primary custody. But while he was married, his lady put him on child support. I don't understand that system. I don't understand how that happened, but he was on it for many, many years and then lost his license and has been paying money every single year to keep trying to get it back. So it's a massive burden. And just some type of resolve. I think this piece of legislation would do it permanently, and everybody, I think, wins in this circumstance.
Thank you, panel, for coming in. So I'm trying to understand, how does a person lose their license without being notified that their license is going to be suspended or is suspended? Can anyone answer that?
Well, I think some of the advocates who worked with some of these folks talked about this a little bit. I mean, I think notices are generally sent out, but a lot of these people are, moved from place to place.
Well, that's a different issue.
And they just don't get the notices.
According to the law, I think you're supposed to keep your current address on your license within 60 days of you moving. Is that correct?
I'd have to check on that.
All right. Thank you so very much.
Thank you.
Further questions? And we're going to hear from Ms. Burton in the next panel because I realized that I missed her there. Any further questions? Seeing none, thank you very much.
Thank you.
We are going to hear from Ms. Burton first in this next panel. We'll hear from her in a moment. Dante Peoples was also supposed to be here virtually, but he's the one who can't be here. Michelle Smith, come on up. Nashana Kess, you were on the first panel, right? Okay, and then Cam Bridges. And I think that's everybody. Cam was on the other panel. Okay, see, this is why. All right. Let's hear from Ms. Burton, then Ms. Smith. Go ahead.
Good afternoon, Chair, and members of the committee. My name is DeWine Burton, and as a resident of District 32, I'm here on both a professional and personal account as a community leader dedicated to supporting parents through the challenges of child custody, and child support litigation. However, I am a Black single unwed mother sharing a child with a divorced father, and I have witnessed firsthand the court hearings and the proceedings that highlight the relational dynamics that can bleed into the legal proceedings. And so these close personal observations have afforded me the unique perspective to remain objective and empathize with both parties and the children involved. Last session, this issue was addressed, and some of you may remember when I testified with my toddler son in tow, and I emphasized the urgent need for reform. However, despite our efforts, the necessary changes were not implemented, and so we're back this year with a stronger bill and a more holistic approach to family law. And so we don't want to have another year pass without these implementations. First, I'd like to stress that the family dynamics in general are inherently complex and never black and white. So when we introduce the legal system into our homes, it often means transferring decision-making power to entities unfamiliar and detached from our unique realities. And the risks from that are sometimes misaligned with our actual lives and cause irreparable damage. Secondly, I have experienced this in my own family dynamic, but you wouldn't believe the number of times I've seen court proceedings where fathers are primary caregivers of their children, and their circumstances aren't adequately considered. And due to court work or motions in process or incomplete court orders, they are unjustly penalized. So they are forced into situations where they are the primary caregiver and still are financially responsible in ways that the court doesn't recognize. Moreover, there are inherent biases towards maternal custody that is sometimes an outdated notion that fails to address the nurturing qualities of fathers, and this undermines the father's roles, but also creates this discriminatory practice for the detriment of court cases for custody and support. I'll lastly want to just say that the bureaucracy of our system overlooks the uncoupling of relationships, so marriages or those outside of marriages. And so the emotional toll that breaking up has is not necessarily something that is taken into account when we have these automatic systems that make decisions for our family. So I'll leave with just saying I'm advocating for the passage of this bill and urge this consideration for a holistic approach of looking at the individual and the circumstances to recognize an individual's ability to pay and support the child or children. Thank you.
Thank you. Michelle Smith.
Good afternoon, Chair and Madam Vice Chair, sponsors, and hello to all you delegates. This is my first time testifying this session, so thank you in advance for all your hard work that I know is going to come. I am here on behalf of the Maryland State Bar Association, the Family Law Section Council. We are private attorneys for the most part who do work on family law cases, which of course includes child support matters. And I'm here to say us too. We support House Bill 311 for all the reasons that have been stated by these the eloquent witnesses that have gone before me and the sponsors. Honestly, I have to tell you just anecdotally that many of our practitioners did not know that there was a lottery system in place, that a machine basically decides right now in our state who's going to be suspended. We're lawyers, so we love the language that codifies factors. We love the language that puts this in the realm of due process. We like the idea that it's going to be a more deliberate determination of who should be suspended. I shared the question that Chair Clippinger asked about who's going to serve these people and how effective that's going to be, because we're already talking about people who move a lot. However, I think the bill in total, from our standpoint, is a plus. And primarily to answer Delegate Phillips' question about would this be a boon financially to offset some of the costs that may be associated with it, I can tell you that our primary custodians, when they call OCSE to say, listen, the other parent makes such and such amount of money, which is a substantial amount of money, why can't I get my child support? They do hear what you heard from the first panel, which is, we'll just wait until the system targets that person. That's not a good way to go, because these people can actually pay. The people who can be targeted by a phone call who are not paying their child support can actually pay, and they can go to court, they can be held accountable, and that's all in the best interest of the children of our state. So we urge a favorable report on House Bill 311.
Thank you. Are there questions for this panel? Delegate Cardin.
Mr. Chair, thank you very much for coming in and testifying on behalf of the bill. I think it's an important bill as well. The Child Support Administration, which would collect them or get the money, right, would go to them to then divvy out. Is that correct?
That is how it happens, yes.
Okay. They have in the past, when we've had this kinds of legislation, not necessarily this specific legislation, but similar legislation, they've come in opposed because they don't want to lose the revenue. Is that fair to say?
I don't know.
Okay.
I'll trust you on that.
Okay. The question is this, as far from a practitioner standpoint, is this going to actually potentially put in jeopardy the ability to reach these people, or is it just going to change the method by which we're selecting how to target the people that we're going to make sure that we try and advocate for or get the money from them? Trying to figure out what's the goal? Is the goal to just change it around, or is it to stop using as a tool the license suspension.
Oh, I don't think that's the goal, to stop using it as a tool. I think it's the methodology of making the tool sharper.
Okay.
That's my understanding. And to that point, it's also my understanding that anecdotally evidence has been collected specifically in Frederick County, where sometimes the people who are being targeted by the system no longer have minor children, as a matter of fact. You know, it could be a grandparent who no longer owes a duty to the minor child, and the money that it's being collected is basically going to other coffers, not directly to a child, because there's no one to give it to anymore. So if that is factual information that's happening, then it's really not for the best interest of the child anymore.
Okay, thank you.
Thank you.
Vice Chair.
Thank you, Mr. Chair. Good to see you, Ms. Smith. Quick question, a couple quick questions. Okay, so is there going to be any problem that you can foresee if an individual, an obligor, fails to defend? Is it going to be, do you anticipate that the judge may very well just say, you know, in some case, you know how in some cases, if you don't show, then, you know, it's presumed that you didn't defend and get default judgment? This isn't quite that, but do you anticipate that as a problem?
I don't. I think that this bill allows for more due process than is currently in place. So I think that's a benefit. If people choose not to participate, then the court system will do what it is allowed to do under the law.
Okay, great. Thank you. I forgot my other question, so
You're
this is
welcome.
great. Thank you.
You can ask me later if you think of it.
Yes. Forgetting your question. It's brilliant. That's wonderful. We like that sometimes.
Yeah.
All right. Sorry. Okay. Are there further questions, or did everyone forget? Everyone forgot. Great. Thank you all very much. That concludes the testimony on House Bill 311. We are done with that. Thank you all very much. We're going to go now to House Bill 300. Is there someone who didn't testify now?
Since the hearing started.
What's the name?
You mentioned that. Oh, you signed off? Yes, he did. Okay, he might have been confused about his waiting. Should I? Yes, because he is not here in the room. Okay. Well, he did submit written testimony.
That's
so
fine.
I would urge you all to read it because it is a very, very powerful story.
All right. Thank you very much. We're going now to House Bill 300. I don't see Delegate Long. I don't think, however, House Bill, he was here. Yeah, I know, just here. I don't believe this next bill is going to take a long time, he said wishfully. It really shouldn't. I know that we have two superstar clerks coming up here, and from I know, so this is going to be an hour and a half or something in the end of two of the best clerks of the state, apparently. Okay, this got exhausting. All right, so love you all very much. We're gonna go. We did this bill last, didn't we?
Yes, we did.
You're back again. So I'm giving Delegate Tolles 2 minutes to testify because we passed this bill, I think, with 1 million billion votes last year. Delegate Tolles, is that right? Don't touch the button again because now we have to wait for it to actually kick on. Okay, thank you.
Sorry. That's correct, Mr. Chair. We did pass this bill a gazillion times. So we do have the best clerk in the state and the other best clerk in the state. So here we are here for not testimony HB 672, but testimony HB 300 this year. Mayor, ceremony, deputy clerk. So good afternoon, Chair, Vice Chair, my fellow colleagues of the Judiciary Committee. I'm here to testify in support of I am the chief sponsor of HB 300, Mayor Ceremony Designation of Deputy Clerk. And as I said, this year is not only Black History Month, but it's the month of love. So for that reason, I asked for a favorable report. HB 300 is straightforward. It transfers the authority to designate a deputy clerk to perform a marriage ceremony from the county administrative judge to the clerk of the circuit court for the county. Deputy clerks of the court the circuit court currently have permission to perform civil marriage ceremonies in the state of Maryland under the authority granted in section 2406 of the family law article. And although the deputy clerks have the permission to perform the ceremonies, the approval still has to come from the ALJ, administrative law judge. It's a bureaucratic step and infringement of the authority of our lovely clerks that are sitting here and many others around the state. Elected clerks perform thousands of ceremonies a year. HB 300 would allow for more flexibility for the elected clerks to manage how they carry out marriage ceremonies in their respective counties. Lastly, as you can see in the fiscal note, it will not have any impact on local operations. And I will close by saying, as the chair stated, this bill passed this committee, JPR, unanimously on the House floor. Y'all know who held it up. It wasn't us in the House. So with that being said, we back here again. And Mr. Chair, thank you. And I ask my colleagues to please support again. And I'll take any questions. Thank you.
Thank you, Mr. Chairman and Vice Chair Bartlett, and the members of the committee for the opportunity to testify in support of House Bill 300. For the record, my name is Mahasan Elamine, and I am the clerk of the circuit court for Prince George's County. The clerks of the circuit court support HB 300, transferring the authority to designate the deputy clerk to perform a marriage ceremony from the county administrative judge of the circuit court to the clerk of the circuit court in each county. So currently, the judges, clerks, and deputy clerks of the circuit court are authorized to perform the civil marriage ceremonies pursuant to 2406 of the family law article. Judges and clerks have the direct authority, but the deputy clerks must be designated by the administrative judge. So basically, for example, this is what happens in Prince George's County. My manager sends me a request to make a change in the designation of who can perform the ceremonies. I, in turn, send a request to the administrative judge requesting an administrative order be passed, identifying the names of the employees who I would like to designate. Then the administrative judge must draft and issue an order. So in a large jurisdiction, this process is very much inefficient. And considering turnover and business needs. Additionally, the clerks believe that this requirement to be an unnecessary bureaucratic step and an infringement on our authority as the elected clerk with our own staff. I do want to note, though, that this would not have any impact on anybody who's ordained, like members of the clergy. Therefore, the circuit court clerks hope that you will give a favorable report on HB 300, and we would like to thank wonderful Delegate Tolles for sponsoring and all of the wonderful co-sponsors. And I'm available for questions. Thank you.
Thank you, Chairman Clippinger, Vice Chair Bartlett, members of the committee. For the record, my name is Scott Poyer. I am the clerk of the circuit court for Anne Arundel County. And like Clerk Alamine, I'm representing the 24 elected clerks throughout the state of Maryland. The clerks of the circuit court support HB 300, transferring authority to designate a deputy clerk to perform a marriage ceremony. Generations ago, the judges performed this, but ever since at least 1963, this process has been done by the clerks of the circuit court. Every year, we issue 30 to 40,000 marriage licenses throughout the state of Maryland, and we perform 10 to 20,000 marriage ceremonies. The judges perform a few marriage ceremonies a year, so we believe that allowing us direct authority to designate our staff to conduct wedding ceremonies that our office is responsible for would be more efficient and reflect current practices. The circuit court clerks request a favorable report for HB 0300, and we would like to thank Delegate Tolles again. Thank you very much for sponsoring this bill. I'm available for questions, and thank you very much.
Delegate Carden.
Thank you, Mr. Chair. I actually have a question just out of process. When you designate a deputy clerk, is it an open designation or is it per event? You say, okay, I'm going to have this person do this ceremony or do the ceremonies this week. Or do you just say, I'm going to designate generally for the next 6 months, anybody can do it. And therefore, like, just let people go and do it when they want to.
So depending on the office size, so like in my office and some of the larger jurisdictions, we have what's called a licensed department. So if you're a licensed clerk and you're designated, you perform civil ceremonies at the courthouse. It has nothing to do with what outside of the office. So if you're in, let's say a smaller jurisdiction, all their clerks may be designated as, available to perform marriage ceremonies, but it's for a while, usually while they're employed with the judiciary.
Thank you.
Thank you, Mr. Chair. Since this is Delegate Toll's bill, I just have to ask this question. This is an extremely good bill, isn't that so?
Of course it is. So sweet.
Madam Vice Chair.
This is a quick question for, not a trick question, but a quick question for Clerk Poyer. Isn't it true that the internet and not the ALJ can give anyone authority to perform a marriage ceremony?
Thank you, Madam Vice Chair. Yes, that is correct. And it takes somebody about 10 minutes to get ordained to perform a marriage in Maryland online. But it takes us several weeks to get authority for our own staff to get it. So this bill is just cutting some red tape. And thank you very much.
Thank you.
Thank you. That's a great
As
question.
pastor of the Universal Life Church, yes, I'm very aware of that. So, any further questions?
I love that.
Oh, Delegate Phillips. Okay, everybody, Delegate Long sitting. All right, come on, Delegate Phillips.
I'm sorry. I just wanted to ask. So you all get to make that decision. That doesn't change anything that the judiciary has the ability to do is still in terms of still performing ceremonies. I just wanted to clarify.
Yeah, that's correct. The judges will still have direct authority.
Yeah, that's.
Unless we want to change that law. Just kidding. We're not.
One bill at a time. Thank
Be
you
nice.
very much. That concludes the testimony on House Bill 300. I think, yes, I didn't see any other questions. House Bill 300? No, I didn't. Could it be here for an hour? Okay. Delegate Long waited so patiently and then got up at the wrong time, and then we skipped him, and now this is the last bill of the day. House Bill 18. It's just him to testify in favor. There's one person to testify in opposition, and we'll get to them in a moment, but we'll hear from Delegate Long for 3 minutes. now.
Actually, that was planned because I figured if I was the last one, I would have all this written testimony I wanted to talk about. Supposed to be. For the record, I'm Delegate Bob Long. I'm here to testify on behalf of HB 18. We've been dealing with problems for the last 4 years about sexual assaults not being reported to the proper authorities, children being in school that have been arrested for rape, also been charged for raping children outside the school. It's been inside the school. I'm sure we all remember the case that happened in Parkville High School. We just recently had, this is a timely bill, we just recently heard that there was a gentleman, I believe he was 15 years old, raped a 2-year-old child and pled guilty to rape. I don't know about you, but I think it's pretty bad. Then we find out he's been charged again in Baltimore County for raping a 2-year-old girl, another 2-year-old girl. I don't know what the outcome of that case is, but this bill is to deal with notification to make sure that everybody involved is aware of it. We had a case in Parkville where nobody knew that this rapist was in the school. And, we did pass legislation in 2022 to help close some of the gap on it, but there's still a big gap. This juvenile is not even on a sex offender register list. The only one that has ability to obtain those records are the police department. So that means that the school superintendent, the state board, State Board of Education, and on down, they don't have access to any of these records. So this child or this juvenile pled guilty to a second-degree rape conviction. We need to make sure that our kids are safe in the schools, and people need to know. And I understand we have to balance privacy. We also have to balance safety for these children in school. Like I said, we did pass some legislation last year that did fix some of the loopholes, but not all of them. Let me just look at my notes here real quick. It was in 2022, addressed some of the concerns at HB 156, but reportable offenses, but it didn't actually go into it deep enough. I don't know about you, but I was quite upset when I heard that this child, 15-year-old rapist, was in a Baltimore City school, and from what I understand, nobody knew about it. Now, I don't know where you're from, but where I'm from, that's really disturbing. And that's why this bill is even more timely than it has been in the last couple of years. And I would ask for a favorable vote on this. And, you know, let's work together and get this loophole closed up and make sure that our kids are safe. And, you know, I would appreciate it. You know, thank you.
Thank you, Mr. Chair. Thank you, Delegate, for being here and for bringing this important bill. I do have a question, but also I just wanted to make sure everybody understood that it was an event. The first one was in Harford County. It was a 3-year-old. He was 14, and he did plead guilty to that one and has now recently been charged with, as you said, actually an earlier event that had occurred, and that happened in Baltimore County. And then he was forced into a Baltimore City public school unbeknownst to anyone in the city. So super disturbing that would occur in Harford County, and that he would be forced into a school in another jurisdiction, I think is a whole other issue that I'm concerned about. Does your bill touch on anything along the lines of sort of requiring virtual learning for people that have these dispositions?
I believe that's already in the law, but it's more up to, I don't know. I want to make sure I'm correct when I speak on that. That actually should have what happened, but this child was actually ordered to go back to school and get a GED. It didn't specifically say he had to go to Baltimore City.
Right.
It said he had to get a GED or attend school, and he could not be in the presence of kids under 15 years old. That's what it said.
And in any school, there will be children under the age of 15.
Right.
Right. Yeah.
And given the nature of the offense of this gentleman, the school should have known about it. I mean, everybody should know about it to make sure that our kids are protected. I think that he should have been on some type of home detention and been homeschooled. That's my personal opinion.
Yeah.
And that's another bill for another day.
Yeah.
But,
Okay. Yeah.
At least we need to make sure that everybody's notified.
Right.
So they can keep an eye on it, and, just so they can keep an eye on this child or juvenile.
Right,
Make
because
sure-
the order was specific, not that he should not be alone with minor children under the age of 15, and yet was put into a school where there is, obviously, he'll have open access to.
Right.
to
I don't
minor
know how you enforce something like that, because if you're in a hall room with a bunch of kids and there's no teachers around, how do you enforce that?
Correct. Yeah.
So it was really a bad call. Well,
Absolutely horrible, super dangerous for the 1,200 kids that go to that school.
I want to know why he was forced into Baltimore City when he's in Harford County.
Yeah, I think the crime was committed in Harford County, so that there's should be some discussion around the appropriateness of a judicial body in one area, dumping a child who's a predator onto another area. That's certainly very concerning. Yeah.
Well, and that's exactly why this bill was brought forth. That way, all the players will know about what's going on. Now, I can't say for sure if Baltimore City knew what happened, this child did.
Yeah, they did not. No, not until the mother came forward and told the school.
That's unconscionable.
Yeah.
I mean, we have the Center for School Safety. We have so many different avenues that we could have notified the parents, notified these schools. That way, we have to make sure that parents feel comfortable sending their kids to school. If they find this kind of stuff out, well, how do you think it makes them feel?
Right.
We have a tough enough time getting kids to go to school. Then the parents get upset. It's just a never ending door. But I would suggest, we need to get this loophole straightened out and, make sure kids are protected and everybody knows. And it's also requires the SRO officer, if they have one there, he would be notified also. So we want all eyes on, on the all on deck.
Yeah, this seems like a reasonable bill. Thanks, Delegate.
Thank you. Thank you for your question.
Are there further questions? Okay, just to clarify the law, the existing law says that they shall notify persons of the arrest and charges of a reportable offense. And that includes the local superintendent, the principal, and the school security officer. That's existing law. So what your bill, it appears, does is tell the State Board of Education, the Maryland Center on School Safety, and it mandates that they tell the state's attorney. So I guess.
Also, yes, go ahead.
So it adds those, but they already were required to tell the school of the arrest.
Well, now, one information that I've gleaned, that the state's attorney don't always notify the different school systems. So I just want to
But
make
this is
sure.
from the police. The police are the ones who provide this information to these different sources, not that they're providing the information to the state's attorney, I guess.
Right, well,
as well. At
once
least
they're
as I
found
read it.
guilty, once they're found guilty and charged, or they're charged and found guilty, I believe the state's attorney's job would be to notify all these different entities as far as, Center for School Safety, superintendent of schools, whoever needs to be notified. We need to make sure that it's clear.
All right. Are there further questions? Seeing none, thank you very much. We'll go now to the person virtually, Ms. Fieo. All right, you have 2 minutes. Please go ahead.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Alyssa Fio, and I'm an education attorney with the Maryland Office of the Public Defender. I'm here testifying in opposition to HB 18 on behalf of OPD, as also on behalf of the Coalition to Reform School Discipline. The coalition is a coalition of advocates, service providers, and legal service organizations advocating on behalf of young people to ensure that there's fair and equitable school discipline, and also access to quality education services. Basically, our goal is to make sure that kids are in school and on track to graduate. We've opposed this bill in the past for several years, and you've heard our concerns in the past. You also have our written testimony, so I'll just make a few points. As was stated, this statute, the reportable offense statute, was amended in 2022. It added significant reporting requirements to the state. It also provided a process in terms of how school systems are to handle reportable offense cases and how to determine whether returning a student to school would cause imminent threat of serious harm. The Maryland State Department of Education is currently, as we speak, promulgating regulations to implement 7-303. And we're also expecting data from the state, statewide data from last school year in terms of reportable offense cases. As was stated, the statute already requires law enforcement to notify the superintendent, the principal, and the SRO. If a student moves to another jurisdiction, the state superintendent can, in a confidential file, transfer that information to the receiving school system. In addition, the state's attorney's office must convey the disposition of the case once the case has been dealt with. What's concerning here is that I'm handling reportable offense cases every day, and we now have a process to determine whether returning the student to school will cause imminent threat of serious harm. And for these students who are most in need, many of whom are students with disabilities, they actually need more services. They need more support services, more counseling services, and more special education services. I don't think that an additional layer of state agency reporting is going to address the concerns that are expressed here today.
All right, there are questions? Vice Chair.
Thank you, Mr. Chair. Ms. Theo, I have one question. What would be the harm in the Maryland Center for School Safety or the school board in having this information? I didn't quite glean that from your testimony.
So the concern is that there is a requirement that an arrest be reported. So an arrest might not lead to a charge. An arrest and a charge might not lead to an adjudication. In our written testimony, we communicated that based on the Department of Juvenile Services data, 65% of the cases that have a juvenile complaint don't even involve any court intervention. So our concern here is that you are passing on very sensitive, confidential information. The juvenile justice system, the confidentiality of this very sensitive information is very protected. And so if you're basically creating like a registry of kids who have been arrested, not necessarily even charged, not necessarily even adjudicated, you are, putting a real kind of vulnerability on these kids that carry this bias with them to have their name associated with an arrest and not necessarily even an adjudication. So I've been very concerned about the reportable offense statute, even as it is right now. It has a very wide net. Any child who has been arrested of one of these enumerated offenses, and there's close to 50, and some of them aren't even really violent. Malicious destruction of property, for example, is on that list. Now, if we have concerns about whether the state's attorney's office is conveying the information or whether law enforcement is conveying the information to school systems, that's already in place. We need to fix that problem, if it is in fact a problem, not create another layer of collecting very personal, very sensitive information in two state agencies. And MSDE is already going to publish information about reportable offenses. It's not going to have personally identifiable information, of course, but I don't think that this bill actually does anything that addresses even the concerns that have been expressed today.
Any other questions? Seeing none. Thank you very much. And that concludes the testimony on House Bill 18 and concludes the testimony today here in the House Judiciary Committee. We'll be back next Tuesday at 1 o'clock. Thank you very much.
Have a good weekend. Take care. I'll go back. All day.